Now, out of all homicide crimes, out of all crimes resulting in death, one of the most misunderstood and most criticized are our felony murder statutes in Florida. Felony murder does not require the intent to kill anyone on the part of the defendant. And the death of the victim does not necessarily have to result from some negligence or some act in furtherance of the felony. There's a landmark case in South Florida whereby a cab driver was being robbed, and due to a heart condition and the stress of the event, he died. It was a heart attack. All perpetrators were charged with felony murder. Now, Florida has adopted the felony murder statute. It's a derivative of common law. It's a common offense in the United States. But other countries haven't adopted it. France, Germany, England actually followed the common law rule and then abolished this type of homicide. So, some things you want to remember when you're thinking about felony murder. The intent of the defendants is not at issue. It's not relevant. Rather, it's the intent to commit a felony and someone died during the commission of the felony. It is irrelevant if it is a victim or an accomplice to the commission of the felony. If an accomplice dies during the furtherance of the commission of that felony, felony murder charges can be brought. Accidental killings are also of no consequence. Felony murder charges can be brought under those circumstances. Now, critics of the rule in Florida complain that an unintended act cannot be effectively deterred. And they point out that deaths resulting in the commission of felonies, the crimes targeted by felony murder laws, are quite rare. In most states, a death that results in the commission of an enumerated felony, that is arson, rape, robbery, or burglary, constitutes first-degree murder. If death results from the commission of a felony that is not listed or enumerated in the jurisdiction's felony murder statute, then the murder is either a second-degree murder or manslaughter. Because the felony murder rule applies whether the defendant kills the victim intentionally, recklessly, negligently, accidentally, unforeseeably, rather than purposefully or intentionally, it creates a form of a strict criminal liability for the death that results from the intentional commission of that felony. Courts in Florida have struggled with the felony murder rule because a murder conviction under the rule does not require malice or intent. Once again, generally speaking, courts have justified felony murder rules in two ways. They hold that the rule dispenses with the requirement of malice, and by holding that malice is implied from the intentional commission of the felony, such charges can be sought, convictions obtained, and sentences imposed. While defenders of the rule contend that it reaffirms the sanctity of human life. Defenders of the rule say that the law reflects society's judgment that the commission of a felony resulting in death is more serious and deserving of greater punishment than the commission of the felony itself, or the commission of a felony that does not result in death. The felony murder rule is also intended to deter negligent and accidental killings during the commission of these crimes. Critics rely on the inability to deter crime, such as felony murder, when it wasn't the defendant's intention to begin with. Now, I want you to think about that, because what we're going to talk about next are what we look for in Florida when we impose sentences for convictions for criminal acts such as felonies. And I want to talk to you about the difference between deterrence rehabilitation, and punishment, to name a few.